Welcome to the Jurist Law Podcast.
Hello and welcome to the Jurist Law Podcast with Kimbro Stephens and Shane Cox. I'm your host, Kevin Rosenquist. Kimbro serves as managing attorney and Shane is chief legal counsel at Jurist Law Group. With rich backgrounds in healthcare and elder law, they help families navigate the complexities of long-term care, asset protection, and estate planning. Kimbro, Shane, great having you here again. Thanks for being here.
Thank you for having us.
Good to be here.
Okay, so today's topic is the great debate. Trusts or wills for your Arkansas estate plan, something that I'm sure you get asked all the time. So let's go through it. Let's just start with the comparison. What are the primary purposes of creating a trust compared to a will?
It's a good question. I think that generally the reason why people would do either one is to make sure their estate goes to the right people when they die. So that's the one thing they both do. You write a legacy plan in a trust or a will, and someone, whoever it is supposed to honor it. The benefit about having a will is that you can actually list a person in charge. Trust, you can do the same thing. They're just called different positions is what it is. So the reason why you would do it is usually the same thing. It's because you're trying to leave some kind of legacy or some other provision, but they're not equal. So, but I don't want to jump to that. I just want to answer your question. That's usually the primary reason why someone creates a will or a trust.
And just real quick, not everyone needs a trust, but everybody needs a will. Is that fair or?
Yes, that is a good.
Okay.
So what I would say about that is everyone needs a will. Mm-hmm. The question is what does the will serve in your plan? Sometimes it serves a major role because it's the only document you have. Sometimes it serves maybe a less major role. I don't want to say it's a minor role because it might play a major role one day, but it may not be the emphasis of the plan. It may not be your primary vehicle. So yes, everybody needs a will because I say every plan is not complete without a will, because if something gets left out of a trust, maybe you buy something maybe you have a beneficiary failure for some reason because your POD is not alive or whatever reason that you've got in your plan. I call that the cleanup document. The will comes along and then cleans up what needs to be done. And at least you have a structure and a decision about what happens to that and who's going to handle it. So the will is always a backup for everything you do in an estate plan.
So back to trusts, what are the most common types of trusts that people would establish? What are the features in those?
Okay. I tend to do a lot of trust, and I talk about this in our workshops a lot. But, there's two basic types of trust. Those are those that are irrevocable. I heard a guy the other day say irreversible. And I like that idea. Irreversible. Yeah. You laughed too because you hadn't heard that one yet either.
No.
And I'm thinking because that's kind of descriptive. When we say irrevocable, we're saying we're not going to change it. We can't reverse it. We're kind of stuck with it. And so in a roundabout ways, that's kind of descriptive of what an irrevocable trust is. And then we have the revocable trust, which is a whole nother group of trusts. There's all kinds of those, but typically revocable trusts are things that you can change your mind on, you can terminate them, you can take your assets back. The irrevocable trust is where you've kind of locked in some things. And we're going to talk hopefully more about the difference between those two in this conversation. But the kinds of things that I like to tell clients is revocable trusts are really not that effective to protect anything. They offer no asset protection. They don't offer any protection for Medicaid as you get older. You might want a revocable trust in your 40s when you have small kids. But by the time you get to be 65 and older, we need to be talking about an asset protection trust to put money aside. And that's where irrevocable trusts come in. That doesn't mean that you don't have control. That doesn't mean you can't decide who inherits. That doesn't mean you can decide who's trustee. You still have all those options. But one of the big options is you can't own that object again, because if you did, it wouldn't do you any good. And I'll just go on to say, I like to tell my clients, I think my clients are living. And a revocable trust avoids probate, but you're not going to be here. So what are you doing all that for? Let's do something for you now. Let's protect your assets. Let's put it in an irrevocable trust because we don't want you to run out of money in your lifetime. Mm-hmm. After you're gone, you're not in probate. Your kids are. And that's important to avoid. But let's do something while you're here. So I'm not a big fan of revocable living trust for senior planning because they really don't do anything for the senior while they're here.
Interesting. Okay. Okay. Yeah. We talked about that a little bit with the long-term care. A lot of this stuff helps the kids more than the parents. And you just have to think about that as like, hey,
Right.
let's make sure that we're not, let's make sure everything's in place so that, when you're gone, it's like, sure, it's not going to matter to you, but you don't want your kids to have to go through a bunch of hoops to try to get this all figured out.
Yeah, but so that's great and wonderful, and that's leaving a legacy if you don't run out of money, because the revocable trust isn't going to protect your money one penny. So let's do something that's going to protect it while you're here, and that means position it somewhere in the family that's available for you, and yet then you have something for the remainder of your life, and then what's left can go to your kids. Let's do that.
So if someone sits down, talks to you guys, and is like, "Do you think I need a trust?" What kind of questions would you ask? What kind of what situations what do you need to know if they need a trust or if they're fine with just a will?
So part of the thing, and this is kind of what we've been dancing around, is that a will not avoid probate. So trust, if they're properly done, they will avoid probate. That's the one, no matter what type of trust it is, it will avoid probate if it's properly funded. So that's the big one. And most people don't want to go to probate because probate can be expensive. It often is long, usually at least 6 months. And, it's arduous, and you have to pay pretty much anybody that submitted any proof that the deceased person is owed the money, which they're called claims. So if you don't want to go through that whole process, you want to make sure and avoid probate. So a will not avoid probate, even though you feel like you're getting your last affairs in order, as they say. You really haven't if you're trying to avoid probate and you've stuck with a will. So with a trust, you can avoid probate and actually have conditions. And it really, depending on the type of trust that Kimbro said, there's a type of trust that actually allows you to have asset protection while you're alive. So you can actually have it both ways. You can be the trustee, which means you can administer the assets of your trust, have creditor protection, and know for sure that you're going to avoid probate, when you pass away. And also, there's a type of trust where you can organize your estate so that if you do ever need to get on long-term care, you'll have that in place.
And I would also add to that, it kind of depends to some degree on how complex your estate is. The more moving parts you have, the more likely you're going to want to trust, because you don't want to have 15 different assets with 15 different beneficiaries on them. Because that gets kind of cumbersome when a trust could actually become the beneficiary of a bunch of your assets. And then the trust then takes care of the contingent things that may happen during life. Another reason that you might want to trust is maybe you have a blended family. And a lot of people with blended families, you can't imagine the turmoil when one of them passes, and then the kids, her kids and his kids, and then, other kids. And so really it's a recipe for disaster when you have mixed families, second and third marriages and things like that. So, who's going to manage all that? Do you want to have a will and go to probate? Well, oh my word. Let's just start, get some attorney fees going here. Okay. So let's try to have a trust in those situations that we have people serving maybe together. So they got to agree and some other things. So one side of the family just can't take advantage of the other. You may think that everybody gets along fine. Well, wait till you're gone. Okay. Yeah. And so blended families are a good reason to try to have a trust. Absolutely.
And how is the trust administered versus a will when the person passes away?
When the person passes and they've created a trust, they have already listed as a successor trustee. So they automatically become the trustee, and it's just usually a matter of getting the right information to the right people. A will is a lot more arduous because you actually have to open a probate and make sure you have a correct copy of the will. And usually a family member has to petition the court for approval to become the executor. So that takes sometimes a little while. And so if you have a person that's passed away and you have a trust in place, none of that's going to go to court. But if there's a will involved, you're going to have to ask the court permission to become your executor. And that's just the start of the probate.
Well, and then, a trust is kind of private. You don't have to air all your dirty laundry.
Oh, yeah.
like you would in a will, where you have to put a notice in the paper and let creditors come and have people challenge the will or whatever. It's a public proceeding. Managing a trust or doing a trust administration is just, you keep it close to home, and you don't have to do all that stuff.
Mm-hmm. Are trusts more beneficial if you're managing assets for minors or perhaps individuals with special needs?
Well, that's kind of my neck of the woods, because I do a lot of the special needs planning in the firm. And really, one of the key things we talk to families about when we're doing estate planning is, are there any kids? Do you have any disabled kids? Do you have any special needs in your family? Because more often than not, if you don't plan ahead, you might even knock someone off of benefits later. If you don't have a plan for it to remain in a special needs trust rather than outright to someone, a trust is most effective in doing that. And particularly for minors, and also for kids that might have drug addictions and other kinds of things. The last you want to do is give them a bunch of money when you die. They may not last the month. So you want to keep things, with a responsible person for minor kids, for maybe people with disabilities, and those that might be at risk of self-harm. You don't want to give those assets outright to people. So you need to have a trust mechanism so they can remain in trust for the benefit of the person without allowing them access to it directly when they may make bad decisions or whatever.
Yeah, absolutely. Are there any tax advantages to trusts compared to wills?
We usually get the step-up basis at death, whether it's in a trust or a will. It's the same thing. There are some trusts that may not get the basis, but when we do our planning for seniors, we don't leave on the table the tax benefits that a will can give you. So we incorporate those in the trust by using power of appointments and other things, so that the person won't have to pay capital gains on assets that are sold upon death. And those two mirror each other. Also, sometimes for high net worth people, I'm talking about people with millions and millions of dollars that may have issues with estate taxes. There are some ways, if you're married, to double those exemptions and things like that. Now, I'll just have to say that I don't have a lot of high net worth clients. Most clients, if they're coming to us for Medicaid and other, we're not doing a lot of those kinds of plans. But trusts for high net worth clients are very important, and because you want to avoid estate taxes. So, but otherwise, income taxes follow whether you've got a trust or not. Any assets of an estate that are continuing to earn income either prior to or after death are all going to be taxed. So that's, income taxes. Like I said, there's two things that are certain in life: taxes and death, right? Mm-hmm. So we're still going to have a few taxes even after we die sometimes, particularly if there's income still coming into the estate.
What are the most common misconceptions or things that people get wrong about trusts and wills? Because I feel like a lot of people don't understand what trusts are in a lot of situations if you don't have any experience. Are there certain things that people really just get wrong when it comes to trusts and wills that you might clear up today for anyone listening?
I think part of the misconception, the most broadest misconception I can see is, one of the things we already touched on was that a will doesn't avoid probate. So if you do create a will, you're still going to the same court, same judge as if you didn't. So the difference is one's going to be handled by Arkansas law because you didn't create a will. The other is hopefully going to be held by the provisions of what you wrote in your will. In other words, if you had a spouse that wasn't on your property, but you want to give them, the property, you do that through a will. If you didn't do that, then it's going to go to your kids with them, with the spouse just having a limited interest. So that is the big one. So when it comes to misunderstandings about a trust, I think the biggest misunderstanding I hear a lot of times is once you get in the nuance. Most people seem to understand a trust will avoid probate. So that is like a big first step. But once you start getting the nuance of these irrevocable trusts, people start misunderstanding, thinking they have to lose all control of their assets. Mm-hmm. And like Kimbro mentioned earlier in the podcast, you don't. Actually, you can still be the fiduciary of all your property as a trustee for your trust in an irrevocable trust, meaning you can buy and sell property. You keep this pot to the side in the trust. You can invest. there's all kinds of things you can use the property. It's just, you're not really fully losing control. You essentially what you are is you're losing control of you personally being able to get the asset principal directly. So versus a revocable trust, you can do whatever you want. You can use it like a checking account. That's why it's not really that good. It's not great.
It doesn't protect you as much. Yeah.
That's it.
Is there a general rule as far as how often you should review, potentially update trusts and wills?
Well, I don't know that there's anybody out there that would specifically say it's X number of months or years. But, really major life events are big. People pass away, people are born, people, get divorced, file bankruptcies. I mean, there's all kinds of things that go on. But generally speaking, every 3 to 5 years, you probably should at least come see your lawyer again and just get reacquainted and see what's happened, because most people, it's out of sight, out of mind. They did something with their attorney and they may never think of it again. And what we tell clients in our firm is, once you do a plan, you can always call us. We don't charge you because we warranty our plan. In other words, it's kind of like a vehicle. If you have a vehicle and we call a trust a vehicle, you're going to put things in it. You can put bags. You got people in there too, by the way. You got all kinds of stuff to carry your affairs through life. And you might need to change that vehicle. You might need to put some new tires on it every now and then. You might need to take some baggages out that you had in there. And so what I tell people is, we should warranty that vehicle too as an attorney. So let's say we've done a trust for you and, things change. You always call us. I mean, you're not lawyers. You didn't write this stuff. You may not understand it, and you've probably forgotten everything we've told you. So you always pick up the phone. You call. You have a question. We're not charging for that because, again, we're not just your lawyer. We have a relationship with you. You can talk to us. That's why we're here today. We're just being conversational. You call us before you make that decision, because you might make one that you regret, okay? Right. You might do something that undoes everything that we've done for you because you didn't quite understand it. So we're always available for those kinds of things. And then, of course, you can always come in and have a meeting with us and get to know, some more details. And then if something needs to be changed, we may need to do some more work. There may be another, partial engagement or something for that. But for the most part, we're always available to talk to our clients, because you never know. And if you say to them, you're going to pay me every time you come see me, well, they're not going to call. Well, that's not what we want. We want you to call us. So now we know we need to help you do something.
Right. All right. Well, good stuff. Thanks for tuning into the Jurist Law Podcast with Kimbro Stephens and Shane Cox. For more information or to connect with their team, visit juristlawgroup.com. And don't forget to comment, subscribe, all the good stuff. We love having you be part of our community here. Kimbro, Shane, so great to chat with you guys again. Thanks for all the insight.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.